وآل محمد. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. لو أنزلنا هذا القرآن على جبل لرأيته خاشعا متصدعا من خشية الله. وتلك الأمثال نضربها للناس لعلهم يتفكرون. هو الله الذي لا إله إلا هو العالم الغيب والشهادة. هو الله الذي لا إله إلا هو العالم الغيب والشهادة. هو الرحمن الرحيم. هو الله الذي لا إله إلا هو الملك القدوس السلام المؤمن المهيمن العزيز الجبار المتكبر. سبحان الله عما يشركون. هو الله الخالق البارئ المصور. له الأسماء الحسنى. يسبح له ما في السماوات والأرض وهو العزيز الحكيم. الله أكبر. بسم الله الرحمن الرحيم. إنا أعطيناك الكوثر فصل لربك وانحر. إن شانئك هو صدق الله العلي العظيم. صلوات على محمد وآل محمد. Assalamu alaikum, brothers and sisters. Welcome to this session of Ayache Table Talks. Inshallah, to continue the program, I would like to invite Brother Karim Jaiba to recite a nasheed named Make Me Strong. Please invite him with a loud salawat ala Muhammad wa Ali Muhammad.
I know I'm waiting for something to happen to me. This waiting comes with trials and challenges. Nothing in life is free. I wish that somehow you'd tell me out loud that on that day I'll be okay. But we'll never know, 'cause that's not the way it works. Help me find my way. My Lord, show me right from wrong. Give me light, make me strong. I know the road is long. Make me strong. Sometimes it just gets too much. I feel that I've lost touch. I know the road is long. Make me strong. I know I'm waiting, yearning for something known only to me. This waiting comes with trials and challenges. Life is one mystery. I wish that somehow you tell me out loud that on that day you'll forgive me. But we'll never know, 'cause that's not the way it works. I beg for your mercy. My Lord, show me right from wrong. Give me light, make me strong. I know the road is long. Make me strong. Sometimes it just gets too much. I feel that I've lost touch. I know the road is long. Make me strong. صلوا على محمد وآل محمد.
Assalamu alaikum, everyone. If you can hear me, please recite a salawat ala Muhammad wa ali Muhammad.
اللهم صل على محمد.
أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. Assalamu alaikum jami'an wa rahmatullahi wa barakatuh. Welcome to the Imam Hussein Islamic Center. It's, as always, a pleasure and a privilege to have everybody here with us this evening. We apologize for the slight delay in getting started. We had some technical difficulties in the form of an unwarranted and unscheduled Windows update, which happened at the very, very wrong time. So my apologies to keeping everybody waiting. Thank you, Brother Ahmed, for the fantastic Quran recitation, and also thank you, Brother Kareem Jaber, for the excellent recitation of that poem. And the whole idea behind that one was to introduce everybody to the subject, a very difficult subject of Islamic wills and estate planning. And inshallah, through this two-part series, we hope that we remain strong and we understand what our obligations are and our duties are towards those that we leave behind, in making sure that our will and our estate is going to be executed properly. With that very brief introduction, I'd like to welcome our different panelists this evening. Sheikh Mansour Leghaei. Assalamu alaikum, Sheikh.
Alaikum assalam wa rahmatullah.
Thank you for joining us, Sheikh. We have Brother Mohamed from Brisbane, who's also joined us. Assalamu alaikum.
Alaikum assalam wa rahmatullah. Thank you for having me.
Thank you for joining us. And of course, we have Sister Rebecca Cramp, who's providing the Auslan interpretation for us. So thank you very much for joining us, Sister Rebecca. As a brief little bit of introduction, of course, you've met Sister Rebecca for the Auslan introduction. Brother Mohamed is has a finance and commerce background, and we'll get to that later on. And really, it's a lot of questions that he had in discussion with various people, and various people have discussed with him and myself, that we thought that it would be a great opportunity to present this topic, which is a very difficult topic, but also a topic that's not that's not discussed very often or in very much depth. And then, unfortunately, the time that it comes to discuss this topic is usually when it's too late, or there are difficulties, or people need clarification on things that the significant party in this discussion is not available because they're usually deceased. Inshallah, we can help everybody to overcome that. And inshallah, this evening we have Sheikh Mansour Leghaei, who's going to provide us with all of the religious instruction and guidance, and also talk to us about the value and the necessity for preparing an Islamic will in accordance with Islamic jurisprudence, and of course in line with your local laws and local obligations. So this is a two-part series. The first part is that, inshallah, tonight we go through the jurisprudence and the fiqh, courtesy of Sheikh Mansour. And inshallah, next Friday evening, we'll have Sheikh Mansour, we'll have Brother Brother Mohamed, and we'll have Sister Rebecca, but also two further guests. Inshallah, we'll have Michael Ayache, who's a lawyer here in Sydney, and we'll have Hajdani Beydoun as well, now, who's well known in the community for providing accounting advice and so on. Now, before we get into the main part of this session, I must say that anything that we discuss here is purely general in nature, especially when it comes to your specific issues. So we'll be discussing things in a general manner when it comes to fiqh. The fiqh, of course, applies regardless, but how it applies to you in your circumstance, it is best that you take the opportunity to discuss with an appropriate scholar at your convenience. When we get to the more technical aspects and the financial aspects, again, all of this advice is purely general in nature, and you should seek your own financial and independent advice that is specific to your circumstance, inshallah. Now, with that out of the way, inshallah, we can get on with the main program itself. I will go straight to Sheikh Mansour, if that's all right, and put it out to Sheikh Mansour. If you could please provide, Sheikh, an overview of why having a will is essential and what the main components are of the will. And if in that you would also discuss, if you don't mind, is there any point of even worrying about if your will will be applied or be executed in the right manner, and so on and so on. So if you would provide that introduction for us, please.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله الذي هدانا لهذا وما كنا لنهتدي لولا أن هدانا الله. Thank you very much, Haj Ali, for a very brilliant introduction. And when I say Alhamdulillah alladhi hadana lahada, I wholeheartedly meant it. One of the reasons I definitely admire Imam Hussein Islamic Center holding this Q&A online, inshallah, tonight, because as I will explain, and inshallah through the Q&A, more explanations will come up. The issue of will is something that by and large, from my experience, the community unfortunately is very much oblivious about. And it's something that on the contrary, they need a lot of education about. First of all, there is a difference between will and testament, so to speak, as in Islamic terminology, we refer to it as al-wasiyya, and inheritance, or al-mawaris, and the law of inheritance. The reason for the significance, your question was about the overview about it, and inshallah, I leave the rest of it through the Q&A, inshallah. Why the overview about the will obligation explicitly mentioned in the Quran. Obligation in certain circumstances, or ethical obligation. We have two types of obligations. One is jurisprudential obligation. Will and testament is not necessarily a jurisprudential obligation. It depends on circumstances. But in some cases, yes, it is. In Surah Al-Baqarah, the second chapter of the Quran, at least there are 3 ayat consecutively from ayah 180 to 182, where Allah subhanahu wa ta'ala introduces to us the law of the will and the obligation of the will. And the tone of it begins with this kutiba alaykum idha hadara ahadakum al-maut. This kutiba alaykum, it is prescribed for you. The tone of it is similar to the prescription of the fasting. So in as much as Muslims, we are supposed to be privy to the rules and regulations and the law of fasting, obligatory fasting. Likewise, I need to know about the laws and rules related to the will and testament. For the same style that Quran says, in fact, the ayat are just few ayat before the obligation of fasting begins. And then inshallah, we go through the discussions about it. Especially for people living in the West, it is more as an obligation to get to know about it. So the financial side of it is one issue, and inshallah we'll deal with it. Another issue that briefly I mentioned, and I inshallah stop here leaving for the Q&A, is don't look at the will only as a financial obligation or distribution of my estate. Of course, this is part of it, but the benefit of the will, as the term says, wasiyya, is what is your life experience that you wish to share with your beloved ones that you are leaving behind. On the one hand, and on the other hand, as Muslims, we believe that the life of this world is like a temporary abode. We are like travelers. Sooner or later, we are going to leave this temporary abode. So the will is constant reminder to me and myself, and to send forth what will benefit me in my eternal abode, i.e. in the hereafter. Therefore, it is so important for us, every single member of the community, from the age of puberty, from the age of consent, we need to know about the rules and regulations related to the will and final testament, and also to know how to execute it. That inshallah, I hope throughout this discussion tonight and next week, we will learn more about it.
Ahsan, Sheikh, and thank you very much for that introduction. Really appreciate that. Sheikh, let's really get to the meat of it. And I think one of the questions that is always on somebody's mind is the question of the rule of the 1/3, 2/3 issue, and really it's often seen as an issue of inequality, or and especially when you get to the share of the male is double the share of the female, and so on and so on. Sheikh, to me, this is one of the most difficult areas. If you could please discuss that and explain to us why it is the way that it is, please.
Yes, sure. Thank you very much for the question, Hajari. That's what I'm saying, that there is a misconception, misunderstanding about will and inheritance. The issue about the share of it, and it's not the share of the males versus females, I will come back to that and explain, is we have in Islam a law of inheritance that in 2 ayah in Surah An-Nisa is mentioned, and there are so many rules about it. And we have a law of will and final testament. What we are talking about here is will and testament. The situation is the following. As a Muslim, practicing Muslim, first and foremost, I'm expected while I'm alive and healthy and I'm able to decide about my financial settlement and distribution of my estate after my death. The best scenario is the following, that first, while I'm alive, and as Quran says, إِذَا حَضَرَ أَحَدَكُمُ الْمَوْتِ, if especially the sign of approaching the hereafter, the sign of dying appears to you, you decide about your estate, how you wish to distribute it, and you have absolute discretion on that. You wish to distribute it among your children, wife, and family members, strangers, how you wish to distribute, this is absolutely to your discretion. If I don't, and that is on the condition that I decide and I change the title of deed to them or bring them as co-owners to my estate. There is no regulation other than whatever that your wisdom dictates. The second step to that, if I don't do this, is coming to the issue of will and testament is a second step, and that is I have authority and discretion over 1/3 only of my total estate, whatever that I own, whether in the form of cash, what I have in the banks, and the details inshallah we'll talk about it, or the real estate, whatever that covers my estate and my property, I'll have only control over 1/3 of it to be decided after my death. Remember, so the first step was before my death, you have full control. If I want to make a decision for after my death, I have only 1/3 of it to control and decide what to do. Even if I miss this stage and I die without any decision, distribution of my wealth during my lifetime, I leave no will behind at all, I just die with some estate left behind, then the law of inheritance come in force and will be divided. So the issue of male versus female, remember, this is the last option, doesn't have to necessarily happen. The issue of will even is happen and be executed if I have executed it while I was alive. As a matter of fact, Imam Sadiq alayhi salam, in a brilliant hadith, I really urge everyone to remember this hadith, as inshallah I always remember and remind myself and people around me that the Imam is giving this advice. This is the will of Imam Sadiq alayhi salam. That's what I'm telling you. The concept of will is not just necessarily limited to my financial estate. Imam says that for your will, write your will, whatever you want your heirs and others, the executor of your will, do after your death, after you die. Okay, once you finalize your will, then you become the executor of your will. Kun wasiya nafsek. I've written my will, completed it, and then didn't you say that give that much charity on my behalf or that charity cause? Imam says that why are you expecting others to give it on your behalf if you didn't give it yourself while you were alive? There's not much virtue to give it after I have no wish on it anymore, or no control, or no hope on that, or no plan for it anymore. I've lost it because I'm dead. Now I say, please give it for charity. So the sequence of the issue of my wealth and property and everything is like this. Number one, the priority is that while you're alive and around, do what you wish to do, to be done on your wealth. Second, for after your death, 1/3 of it. Third, in the absence of the first two stages, then Islamic law of inheritance comes. Now, about the Islamic law of inheritance of the boys versus the girls, to understand any law, you need to put it in its context. Likewise, to understand the law of inheritance, you need to put it in the Islamic context. Within the Islamic context, first of all, it's not a male versus female. Let me clarify this, for the reason that in the law of inheritance, mom and dad, they take equal shares. If I die and my parents are alive, the share of my mother as a female will be equal to the share of my father as a male. That's what I say. It's not male versus female. Yes, when it comes to children, boys versus girls, boys get double of the girls. But when you put it in the Islamic context, you will see that as a matter of fact, Islam has given more share to the girls versus the boys. Unlike the sound of it. Why? Because true that my son gets double of my daughter, for example, but remember that I had the opportunity in my will to give her something, I didn't. I had the opportunity before my will to even transfer some of my estate to her, I didn't. Now, my son has certain obligations. If his mother is alive, he has an obligation towards the maintenance of his mother. One may turn and say that, but what if the mother has passed away? Usually as a married person, he has an obligation to look after his wife and children. So the scenario, and there are so many fiscal obligations within the Islamic context that God has put on man that the woman is free from. And that's why when it comes to inheritance, somehow God is compensating the man. It's just like imagine that we get some social benefits and there are two families. One has a big family, another one is a single person. Naturally, the government, the benefit that gives the single person will be much less than the one who is supposed to run a big family. This is the notion behind it. It's not about gender discrimination or anything like that. Whatever that my daughter owns, whether married or single, will be entirely hers. Whatever my son owns, he has expenses that Islam has imposed on him. He gets married. At the time of the marriage, he is the one who's supposed to give the nuptial gift. His wife is the receiver of the gift. The husband is the giver of that nuptial gift as an obligation. And many other. We need to go through the list of jurisprudential issues that I don't want to prolong the session.
So, Sheikh, thank you very much, Sheikh. So, on that, on what you've just mentioned, it seems like there's two ways of going about this. If before your death, you prepare a will within Islamic guidelines and according to the jurisprudence, you have a certain amount of control over how you allocate your estate and so on and so on. However, if you pass away, if you die without having prepared a will, then the Islamic jurisprudence applies in a very specific way and then distributes it that specifically according to the jurisprudence and not necessarily in the way that you would have done so anyway.
Correct. See, quickly, I repeat, there are three stages, Hajali. The first stage is that while I'm alive, I bring my children, my wife, whoever I like them to be the beneficiaries of my estate, bring them as part of my co-owners. In a technical term, we call it they will be my co-owners. By law, they will be the owners, not that as a will. Nothing, we haven't started the will yet. They will be the co-owners of my will. And then I hold the right of, we call it the right of survivorship. That so far as I'm alive, I still wish to have this house. But the moment that I die, this house will be distributed equally among my children and my wife. This is one step. The second step, if I don't do this, I write a will and I say that after my death, I wish this house, like for example, 1/3 of the whole value of the house to be given to my daughter, to be given to my wife, to be given to a stranger. This is will that we are talking about. So the will is within 1/3 of the total estate. If I even miss this stage and I don't do, I just die without anything at all, then and only then the law of inheritance comes in force.
Ahsan, thank you very much, Sheikh. That's a lot clearer now. I did want to ask another couple of questions around that concept, but inshallah we'll get to that point. We'll get to that. If I can just comment, the first scenario that you described, I think, is commonly referred to as having a living will, where you gather your descendants and the people that you wish to be a benefactor of your estate, and you either document the intention or you actually do the transfer of ownership or and the distribution of your wealth and estate, et cetera, whilst you're still alive. Of course, like you mentioned, there are still some conditions and things, but it's often referred to as a living will. And that's like you've said already, it's probably the best way to do it, to make sure that you avoid any issues after your passing. I think Brother Hasnain has Brother Mohammed has a few questions that he'd like to run through with you as well, Sheikh. So over to you, Brother Mohammed.
Thank you, Hajj Ali. Assalamu alaikum, Sheikh Mansour. Sheikhna, you mentioned about the 1/3 share, and you gave an excellent explanation of how it can be used to make the share of your daughters equal to that of the son. Now, is that the only purpose that we can use the 1/3 for, or could we potentially leave an amount to a charitable cause, for example?
Thank you very much. Very good question. Actually, the notion of the will and 1/3, which by the way, the threshold is 1/3. Islamic recommendation according to the Rawayat is that depending on your heirs' financial status and their needs, if they are more in need, reduce that 1/3 to 1/4 or 1/5 or less, so that they benefit more from your estate. And if they are, inshallah, well off, then up to the maximum of 1/3. And will is not just to compensate my daughter or my wife or any of the beneficiaries of the inheritance. The first and foremost benefit of the will is to look after myself for my life after death. So that, there is an ayah in Surah Al-Munafiqun, I think, that Allah subhanahu wa ta'ala shows a scenario to us that there are certain people that upon their death, and as soon as they die and the veils of dunya are removed from them and they see the life after death, they have a wish. Their wish is, God, just delay my death a little bit. To do what? Quran says, quoting from them, فَأَصَّدَّقَ وَأَكُن مِّنَ الصَّالِحِينَ, so that I become charitable. So the will is that in my lifetime, I made a mistake, unfortunately, or I was a bit slack, so much into dunya and saving. I didn't give enough charity. Now I want to say that whatever that I've left with, to the maximum of 1/3 of it, please give it on my behalf, my sons, my daughter, my wife, my family. So the first reason that I need to write the will as financial side of it is to give some charity for some charity causes. Yes, at the same time, I have the discretion to give all of it or part of it as I deem appropriate, to give to some of the beneficiaries of the inheritance that I may think that they are more in need, whether male or female. That is also possible. Note that what the Quran says, when it comes to the beneficiaries of the will, al-walidain wal-aqrabin, your parents and even your relatives, whether maternal, paternal, whether by marriage or by like genetically, sababi, nasabi. So you can so in your will write something to be given to my aunt, or one of the far relatives that they are in dire need of it. So yes, will first and foremost is expected to be a charity given for charity causes.
Jazakallah khair, Sheikh. Now, I think we've got a question from the audience. Might be a good time to ask that one now. How often do we need to review our will during our lifetime?
Ahsan, very good. Anytime that circumstances change, it's good to renew and update your will. I give you an example, and just maybe from myself. Write your will. The Rawayat says that it is mustahab by default to have a will. Please, I hope that inshallah every single member of the community watches this program sooner now or later, and make sure that they write a will. You don't need to be your 70s, 80s, 90s to write a will. Unfortunately, sometimes as people are getting older, they become scared of writing the will, or the youngsters, they are jokingly saying that I'm not ready to die yet, so I don't need to prepare a will. Nobody knows when and where and how we are going to die. Write your will. It's a very good practice of self-building. So I've written, say my will, and we'll talk about the details of it, put it in an envelope in a traditional way, and seal the envelope. The way I seal it, I just sign and put a sticker tape on it, 6 months later, 1 month later, 1 year later, I wanted to go for a ziyarah, and after I come back, I open my will. Believe me, brother Muhammad, such a feeling is there that is, we need to experience it. When you open the envelope, you get a goosebump because you're not supposed to be the one who opens this envelope. And then read through it. The Almighty God bless me to come back alive. Didn't you write in your will, please give that much as charity for me? Who is better than yourself to give it? Give it while you can. So to renew and update the will, do it as often as you want. There is no Islamic restriction for that, but especially when circumstances change. Okay, the properties changes or anything changes, or you come up with some new ideas, new insights. Do you want to share it with your family? Add it and update it.
Ahsant, Jazakallah khair, Sheikhna. Now, related to the will, the 1/3, the overall, is there somebody in particular that we need to appoint who's responsible for taking care of this after we pass? Are there any guidelines to this that the fiqh provides to us? Can you please elaborate on that?
Let me introduce these terminologies. The dying person in this example, myself, who is writing the will, is called testator. So I am the one who is writing the will as a testator. The recommendation is that naturally I need to appoint someone. Of course, if I don't appoint, the jurist and marja will appoint someone, but better that I appoint someone as the executor of my will, he's the one who executes my will, the executor. So the will executor is the one that I appoint to act on my behalf. We have a template actually developed some years ago. We may talk about that as well. The recommendation is that the executor that I appoint, it can be inheritance beneficiary. Like, for example, one of my children can be executor, doesn't matter male or female, can be my wife, can be a stranger, can be the sheikh of my local masjid, anyone that I trust. As long as that person is a trustworthy person, you can appoint them. And of course, wise and healthy, you can appoint them as the executor of your will. It's always better to give also a second person this task as well. In case this Mr. A, for example, predeceases me, then or happens that he is not available, then the second person. So the one who is executing my will, yes, he is the executor of the will. And in my will, I'm supposed to mention and give his details.
Ahsant. Now, I'm just going to jump for a second to the side of the executor or of the potential executor, let's say. So let's say somebody approaches you. Sheikhna, you approach a friend of yours and you say, will you please be my executor? Mm-hmm. Do we have a responsibility to say yes, or do we have the option of saying no?
Very good question. The reason that I say very good question, because there's a jurisprudential discussion on this question. It depends on the situation. If I approach someone and I say, Brother Mohammed, can you be the executor of my will? While I'm alive and around, you have the option. Jurisprudentially, you have the option of accepting or declining. Maybe you say that, Sheikh, sorry, I cannot do this for certain reasons. Please excuse me. Then I can go to somebody else. But if I write in my will that I want Muhammad to be the executor of my will, and then I die, and then the will is recited, and you see that, oh, Sheikh has appointed me as the executor of his will, this is where the controversy is, that do I still have the obligation to accept it? The riwayat says that don't put your Muslim brother, the deceased Muslim brother, down. He has already appointed you, unless really there are circumstances that is impossible for you. Otherwise, the strong recommendation is that take that obligation and accept it to be to execute his will. I hope it answered your question.
Absolutely. Thank you very much, Sheikhna. Haj Ali, is there any questions which are coming in from the audience?
We have actually. We have a question from Facebook. The question goes along the lines of this. Salam, how about having no children? My siblings are not Muslim, there are nephews and nieces who are Muslim. Do my Muslim relatives share the inheritance, or what happens in that case? Also, further to that, what do I do about my non-Muslim relatives? Can they inherit or can they not? What is the jurisprudence behind that?
Okay. Speaking about, first of all, remember again, don't mix up the will with the inheritance. If it's the will, you have the discretion up to the 1/3 of your estate for after your death, or the full estate during your lifetime, to give it to whoever you wish. Muslim, non-Muslim, relatives, non-relatives is not an issue. But that's what I'm saying, that usually people mix inheritance and the will. They need to understand that these two are two complete separate subjects. Speaking about the inheritance, no, inheritance is limited only to the Muslim heirs, not the non-Muslims. And even for Muslims, we have different classes or different categories. The first category, like for example, and it's a real example, of course. When I die, if my parents are alive, my parents, my wife, and my children will be the first category of the beneficiaries of my inheritance. Inheritance, remember again. In the absence of my parents, my wife, and my children. In the absence of my children, the questionnaire has assumed that he doesn't have any children. If his parents are alive, they have a share of the inheritance. If his wife or husband is alive, they have a share of the inheritance, each depending on the circumstances. And if I die and I have no parents, no children, and my wife also predeceased me, then this goes to the second category. The second category will be my siblings. If I don't have any sibling, but the children of my siblings are alive, it goes to my nephews and nieces. You see, all these are discussed as different classes of beneficiaries of inheritance. Again, I want to reiterate, this is for inheritance, not the will. The will, you have absolute discretion as how you want to distribute it within 1/3.
Ahsan, Sheikh. I think it's a very technical discussion, and it can become confusing very easily, especially for me. But it's good that you're pointing out the Islamic approach to the difference between what is a will and what is inheritance. So, Ahsan, thank you very much for doing that, Sheikh. Now we have a few really technical questions as we go through now. And I'd just like to remind everybody on Facebook, on YouTube, and also who've joined us on Zoom, you're welcome to join in with any questions and send us any questions that inshallah we'll get a chance to ask those questions. We do have a question here that I think will help clarify something. A person has asked, if I want to distribute my estate whilst I'm still alive, do I need to give the male 2 times as much as the female? So is it still the same ratio, or is that entirely up to my discretion?
As I explained it, absolutely entirely to your discretion, so far as you decide and to change the title of the deed to whoever beneficiary you want to choose. So while I'm alive, I have absolute control over my estate, whether to my children or strangers. Again, as I said it before, it's absolutely yours and your wills. Whatever you want to decide, you decide. Although the recommendation is, even though I have the right to give it all for charity, let's say, it's a very good and godly cause, but the recommendation is that don't ignore your children and your first family.
Certainly, Sheikh, even Australian law says that don't ignore your relatives, but there's a whole other set of reasons for that, but inshallah, we'll get to that. Sheikh, there is one more question that's related to the formation of your will and making sure that it is sahih, if I can put it that way. From one of our viewers, Assalamu alaikum, dear Sheikh, does the will need to be witnessed by 2 people? Islamically and legally, based in Australia. So that's legally we'll speak about under Australia we'll speak about next time. And Islamically speaking, who can witness it if it is required?
Alaykum assalam. As for the legal side of it, I leave it inshallah for the next session when we have a solicitor around. Islamically, there is an ayah in Surah Al-Ma'idah, if I'm not mistaken, that Allah subhanahu wa ta'ala says that at the time of you want to make your will, make sure that you have 2 male just witnesses. Dawa adlin minkum, 2 male just witnesses. This is for the two witnesses are necessary if I'm making a verbal will. So because it's verbal, two witnesses are required. In fact, they don't have to be necessarily male. It could be male and females. They don't have to even be Muslims. It is clearly mentioned in the Quran and in the Rawayat as well, and the Fatwa, that even if they're non-Muslims, as far as they're trustworthy, that they come and they say that, yes, we were there. Before he dies, he verbally mentioned this as his will. It will be acceptable, especially when there is no one denying for with evidence. But when I'm writing my will, and there is, it's especially my handwriting, that my family knows that this is my handwriting, and I wasn't forced to write it like this, voluntary, and I mentioned that this is my final will and testament, voluntary, at this date I've written and I've signed it, and the family knows my signature, knows my handwriting. Nobody I had around me to hold as a witness, still is fine. Still is fine. So remember, the issue rotates around how much you trust the verbal communication or the written text of it. Recommendation is that make sure you have two witnesses to avoid any dispute or any misunderstanding in the future. It's always best. Sometimes people say, but I don't want anyone to know what I've written in my will. I tell them that I've been sitting with so many clients when they come to me with preparing their will. I tell them that, look, I can be the witness to your will, and I don't need to know about the context of it. Last page in our will, page number 9, give it to me, you sign, and I testify, and I write that, yes, he signed in front of me as like a justice of peace. That's all about it. I don't need to know about the contents of your will.
Ahsan, Sheikh. There is a follow-up question, which I'll get to in a second, but Sheikh, you've mentioned that a will can be narrated to two just people. Sheikh, we have a problem with sometimes making sure all of our hadith have been narrated correctly down the chain, and you're saying that we can do that with a will. I can't imagine the kind of problems we'd have if that was the standard that we applied today.
That's why actually quoting a hadith from Imam Ja'far as-Sadiq alayhi salam or any Imams is a very technical task, very technical. You have to make, just because it is mentioned in a book, I won't just pick it up and say that Imam Sadiq said so. I have to look at the chain of transmitters to make sure they are trustworthy and meet all the criteria, and then inshallah I can say that Imam Sadiq had said so.
Ahsan, Sheikh. As a follow-up to the previous question about how to share that, how to distribute one's estate amongst Muslim and not Muslim, etc., etc., the follow-up question is that when you mentioned that if you use a living will where you distribute your estate whilst you're still alive, the question is, how are there guidelines on how to be equitable and just in distributing your estate? How does one make sure that I've addressed this person's need, or I've given fairly to this niece and to this nephew, or so on and so on? Is there some sort of guidance you could share with us?
The only term, at least the only term that is explicitly mentioned in the Quran as the main reference for that is this term, للوالدين والأقربين بالمعروف. بالمعروف is a term that Quran is, this is the code Quran is giving us. بالمعروف means equitable. بالمعروف means that use your common sense and then distribute your wealth to the best of your knowledge. This one, I believe that is in more financial restriction, needs more. That one is okay, may need less, and act like this. If you're not sure how to distribute it, always you can seek the advice of somebody else to make sure. It's so important. I'm happy you brought this question up of the equity and being fair. Ajali, there are riwayat that if I write my will, I hope I get the attention of everybody for this very essential statement I want to make. Hadith from the Imams of Ahlul Bayt alayhimus salam. They say that if you write a will and you are not being fair deliberately, sometimes ignorantly, but deliberately, I'm not being fair and I'm being biased, فَقَدْ خَتَمَ عَمَلَهُ بِمَعْصِيَةٍ. I have concluded and ended my life by sin, because I haven't been fair to my children, I haven't been fair to people that were beneficiaries of my will. So it's a very delicate task. To the best of your knowledge, try to be fair as much as you can, inshallah.
Thank you, Sheikh. Just to close off that particular area, I think you mentioned earlier that the best way to distribute your estate is to do it while you're alive, to ensure that it has been done in the manner that you intend, and also that should some circumstances arise, you can deal with it whilst you're still alive, and you're not relying on the jurisprudence or somebody's understanding of your will to be able to distribute that.
Always is the best to sit with the family members, nothing to be scared of. And again, please, when you are writing your will, you speak about your will, family members must have this very good understanding. That doesn't mean that dad is dying tonight. No need to be scared of. No, astaghfirullah, please, dad, don't talk about this, mom, don't. No, by all means, talk about the will time and again, time and again. It's so healthy spiritually for me and for people around me, inshallah. And at the same time, we can come to a very good common understanding.
Ahsan, thank you very much, Sheikh. Sheikh, we want to get into some of the real detailed areas, and I know that we're pushing through the time that we have allocated. So inshallah, let's really start on some of the real technical areas, if you will, such as how is the value of an estate calculated, and do we take the net of assets and liabilities? Let's say, for example, one day I'm going to pass away, and I know that I have an estate to the value of $100, but I have debts that are $60. Is it the net? Is it how do we calculate that? What are there different methods or different ways to do it? If you could elaborate on that for us, please.
Sure. First of all, when I die and I say that I have written a will, clearly Quran says, "Min ba'di wasiyatin yusi biha aw dayn." Inheritance and the division of the law of inheritance comes in force right at the end. Before that is my will. Before that is my debts. So if I have any debt, any outstanding debt, let's say that I have some outstanding bills that need to be paid. Let's say there is a mortgage on this estate that needs to be paid immediately or in due term. And in the Islamic law, actually, it is recommended, or it's a law that if I die and there is any debt that even though it's not due now, it will be due in 2 months, 3 years, still the creditors, they have the right to come and claim it right now because I'm deceased. So debts always are to be paid first. And then we have this discussion. I don't know whether I need to go to more details or not. When it comes to the debts that I have to humans get the priority to the debts that I have to God. That means that if I owe you certain amount of money, or your company or the banks, anything, this debt is the first priority to be paid before. Like I had to go to Hajj and I didn't go, so I have a Hajj on me that somebody has to be paid to do the Hajj on my behalf. Hajj comes the second priority. The first priority is to give the debts of humans, individuals. Okay, like for example, if I haven't paid the nuptial gift of my mahr, something that many men are oblivious of, that it gets the first priority. From the total estate that I've left behind, my wife has to be paid for her nuptial gift or mahr. Another individual that I owe them has to be paid. Anything left, then we talk about the law of will and final testament.
Hassan, Sheikh, you know what's straight after this session, I'm sure many husbands and wives are going to look at their marriage contract and say, what was my nuptial gift that you were supposed to give me?
And you know that in Iran, what they do, because some people, for example, got married 40 years ago, and before he dies, 40 years have passed. So what they do in the court, they calculate it. They say that at that time, he committed himself to give his wife certain amount of money. Today's calculation will be that much, so usually much more. So the sooner you pay your wife's mahr, the better is your.
That's actually a great system, Sheikh. That's fantastic. I mean, it accounts for inflation, et cetera, et cetera. That's brilliant, and that's securing your wife for her future, inshallah, if you've passed away as a husband.
Hold another session about the mahr, because there's a lot of misconceptions about the mahr as well.
That's a great idea. Maybe in a few weeks' time we could look at that. Should we have maybe one of the sisters host that session?
Anyway, they will be attending it.
Yeah, of course, of course. Sheikh, when we're looking at assets and liabilities, what sort of things do we include? For example, do I include all my household items? Do I include the food in my pantry? If I've bought it, if I know that that's if I own that, do I include my clothing, my computer, my this? So what sorts of things are included as my assets? And on the other side of that, what sort of things are included as my liabilities? I mean, my phone bill, this or that. Is it just the big things, or is it everything?
Technically speaking, anything that is considered my property and mine after my death will be on the table and supposed to be on the table. But I doubt it if this is on a very technical term. But inshallah, usually the family members are not going to be so nitty-gritty on I don't know, food items, things in the fridge and and stuff like that. But speaking about the bills, yes, for sure. Any bills that are my bill are to be calculated. Although I must mention that when it comes to kafarat, for example, I had some lapse fasting that I had to pay kafara on it. This kafara is not part of the obligation. So the heirs can say that, and let's say that I died with no will, and but my children know that dad had to pay some kafara for whatever reason, whether during the Hajj something happened that he had to pay kafara, or because of fasting, or any other reason. Kafara, it is not deducted from the total estate. They can take their share. If from 1/3 there was anything to pay the kafara, they pay. Otherwise, on a very technical term, the heirs can say that, look, none of our business. Tough luck, he should have paid it himself. I'm sorry for the sound of it, but on a technical term, that's how it is. So kafarat are not the same as a liabilities. It's my liability, but kafara is different from Hajj. It's different from my debt to an individual or a company or things like that. Because kafara is a kind of a penalty. Like perhaps we can, in today's terms, I'm just deducting it. I passed a traffic law and there was a ticket also as well. That's my bill. Okay, but do the heirs have the obligation to pay this? Are they liable for this? No, they are not liable, because it's kind of a penalty that I had to pay. Tough luck that you shouldn't have driven so fast.
Yeah. Sheikh, now a question.
Don't do it, but I'm just saying a very pure legal term.
No, of course, and inshallah, we all have descendants who will primarily look after their parents' needs even after they've passed away. Inshallah, may God bless us in that manner. Sheikh, we're in a situation where a husband and a wife have joint ownership of a house or a bank account or something, and we could get in even more technical that, you know, I've put in only 30% into that house, or I've only put in 30% of the value of that bank account. But let's set that aside. Maybe that's getting too technical. Let's say that's jointly owned, it's been jointly invested into or jointly bought together, and I pass away. How is that then distributed? How would that be distributed? Does it also involve selling that property or liquidating that asset? What would happen, Sheikh?
First of all, make sure that that's what I say, that really writing a will in practice becomes very significant and very obligatory upon all of us, because of especially such things as clearly Quran says, especially when you have some estate that needs to be decided, especially if you're in partnership with someone, whether your wife or a stranger. In the will, you can determine that clearly, and your solicitor endorses that the percentage that you own, whether it's half, it is 30%, 70%, then the calculation will be very, very easy. Of course, the calculation will be based on my whatever that I own. More than that, I have no say in it, and it's not mine. About the selling that property, liquidating that property, once that property is distributed or potentially supposed to be distributed to the heirs, there are two situations. One is that one of the heirs, in this case, for example, my wife and children, one of the children come and says that I'm willing to buy the share of everybody else, and the remaining mortgage will be also on me. He has the right to do this, and he, in fact, the partners to that potential property have the priority. We call it haqq al-shuf' in the Islamic terminology. He has the priority. Like if there are two buyers, one is stranger, one is my son, my daughter, my wife. The one as a family, they get the priority because he's one of the beneficiary or she's one of the beneficiaries to that property. Okay, so they sell it or they will wait. Many families, and that's a good thing to do. I need to mention the ethical side of it as well. I die, my wife is still alive. The best way is to leave the property for my wife, let her live there. And once the time that comes that she dies, then the children divide it between themselves or whatever that they want to do with it. So about liquidating and selling it, yes, as a jurisprudential rule, we have this, that it's possible to, for someone, one of the beneficiaries to buy the share of the rest or sell it and then divide it accordingly.
Ahsan, thank you, Sheikh. What I'd suggest, if you don't mind, Sheikh, what I'd suggest is if somebody is in that situation where they have that joint assets and things like that, the best thing to do is to get some advice, to sit with a scholar such as yourself, Sheikh, and to go through the details of how it's been set up and so on, just to avoid any issues down the track.
Ali, can I add to that? In
Of course,
fact,
please.
anyone who wants to write their will, unless they have an Islamic education, otherwise, with all respect, definitely I suggest, please, that's again another statement I'll need to attention of everybody. Writing your will, please make sure that you see it with a scholar to make sure that you're writing your will correctly, not just for the financial side of it, even the non-financial side. I want to write about my will. I've had so many clients. A lady comes to me and she says, Sheikh Mansour, write for me to 40 years of praying to make the qada and pay someone to make 40 years of salat for me. I said, but Haji, haven't you been praying? She says, yes, but just to be on a safe side. Who are you going to find to pray 40 years for you? And apart from the fact that somebody needs to be paid on that. So, but once they write it and it's finalized and I die, the heirs, they have to execute it. Otherwise, they are sinful, according to the Quran. So it's so important to write your will under the supervision of a scholar to direct you what is the right way to go about it, whether financial or otherwise.
Ahsan, thank you, Sheikh.
Ali, I am edging to get in here, if you don't mind. I've got a few questions.
Please.
Thank you. Sheikhna, you mentioned that your debts or your liabilities are deducted first. But what happens if your debts are greater than your assets? What's the situation there?
There are some technical issues here. I don't want to go too much technicality, but on a broad level of it, I can discuss it, but it requires a little bit of more time and attention. On a general term, usually the liabilities, if it's greater than 1/3, that is the will, the heirs have no liabilities. Let's say that, like to put it in perspective, let's say that I die and the 1/3 of my total estate sums up to $30,000, but my liabilities is $40,000. The remaining, the balance of $10,000, should it be taken from the rest of my estate? Because remember, the remaining 2/3 belongs to the heirs. The heirs have the right to say none of my business. That's dead, none of my business. So they have no liabilities. This is in a general term. There are certain circumstances otherwise, but in general, this is the answer. That more than 1/3, there is no liability to the heirs or the beneficiaries.
Ahsant, Jazakallah khair. Sheikh, we've got another question which has come in from our viewers, and it's related to what you were discussing with the house and the joint ownership. So can one partner write in their will that the other partner can continue to reside in the residence of which they are 50% owners?
All right. Again, it depends on the way that they do it. The best way, the safest way is, the reason that I say it depends because we have to look at the total estate again. If that is not exceeding, that house is not exceeding 1/3 of the total estate, yes, by all means, he can write a will. But if it may exceed the 1/3 that steps to the property, to the wealth and the belonging of the rest of the beneficiaries of the inheritance, the best way is to write it, and they can sit with a solicitor. Maybe next week we can get confirmation from our solicitor that I write it while I'm alive, that look, this property, my wife and I, we are the co-owners of this property, although I have the right of survivorship. That means so far as I'm alive, it's mine and hers. But as once I die, it will be all hers, and nobody has the right to touch it. This is possible. They can do it this way.
Excellent. I think that answers that question definitely. And we've got a question. You mentioned you've spoken a lot about 1/3 during today's session, but we've got a good question asking, the fiqh rulings specifies what happens to the other 2/3, but can you give us a general overview, please, of how that 2/3 is distributed?
Again, please, I need to remind ourselves that the 2/3 or all of it, first scenario, ideal scenario is that while I'm alive, I've distributed it. By the time I die, whether as a will or as an inheritance. This is an ideal situation. If I miss this one, I have written a will, 1/3 will be the will and will be divided according to my will. The remaining 2/3, goes under the law of inheritance. And the law of inheritance has its own set share for everyone. Parents, they have their own set share. Children, boys and girls, they have their own set and things like that. So in the absence of the first step and the second step, the 2/3 or all of it, sometimes if I don't have any will, the total estate actually goes under the law of inheritance. And it's so fixed, no one can change it. Even in my will, I cannot write as a will. I cannot write it that, please, this is my will. I don't want you to divide the inheritance, boys twice of the girls, because I'm writing something against the will of God. It will not be acceptable.
Ahsan, Jazakallah khair, Sheikh. We've got the questions really coming in now. Another one that we've got about the law of inheritance, very popular section here. So you discussed the most ideal scenario, which is to distribute things before you pass. Can we use the law of inheritance and the shares specified within that to distribute while we are alive? Is that recommended as such? I know you've touched on this, but I guess more just a clarification of what you advise.
While I'm alive, remember that everything, my estate is in my absolute discretion. So I have the right to divide accordingly. What Quran says, the ayah that I quoted from Surah Al-Baqarah, ayah 180, bil ma'ruf. Just as long as you are being fair, then that you should be safe and you'll be on a safe side. And if you distribute it, let's say it's a situation that your daughter, she needs more than your son, but you say that the law of inheritance says that son twice of the daughter. It is my fault, because the law of inheritance is like a what you call like a module, like a template, general template. But in my personal situation, I know that my daughter is in more dire need than my son and deserves more than my son. God has left it to me to decide, because every individual knows about their family situation better. So if I'm distributing my estate in my lifetime, I need to be bil ma'ruf. The term used in the Quran is bil ma'ruf. Be fair and assess the situation of every beneficiaries and give their share accordingly.
Ahsant, Jazakallah khair, Sheikh. Now we've got one more question, and it's a little bit scary, I must say. So we hear a lot about wills and inheritance, and families falling out within Western society. We also hear a lot about people contesting wills. Now, from your experience, have you come across cases where wills have been contested? And if yes, can you please give us some advice or guidance on how to potentially avoid situations like those?
There are two situations or numbers of situations. One is that if I write in my will that I don't want my certain child or beneficiary, potential inheritance beneficiary, to receive anything at all, this is forbidden. I have no right to do that. Unless Islamically is justified, otherwise, by default, this is forbidden. And the hadith that I mentioned, فَقَدْ خَتَمَ عَمَلَهُ بِمَعْصِيَةٍ, he has ended his life by sinning, applies to me. So I have to leave it the way that God has left it, because, sometimes some parents have an issue with one of their children and they want to take revenge from him. That is not the time for it, and it's not the right thing. Another scenario is the other way around. I have written my will and I've decided 1/3 of it to be given to certain cause or to be distributed in certain causes. And the beneficiaries of my inheritance, they come says that, no, Baba, ignore it. I need it myself. As he should have left it for us. Quran says, فَمَنْ بَدَّلَهُ بَعْدَ مَا سَمِعَهُ فَإِنَّمَا إِثْمُهُ عَلَى الَّذِينَ يُبَدِّلُونَ. That's a mortal sin. You cannot, once the will is written and finished, the heirs have no right to change it. Okay, so either side, it is incorrect and it is a sinful act to do.
And just following on from that, would then you recommend that our executor of our estate not be a potential beneficiary?
Purely from the jurisprudential point of view, it is possible that one of the inheritance beneficiaries is also the executor of my will. Even though I understand legally they may call it conflict of interest, but as far as that person is trustworthy, Islamic jurisprudence allows that, especially when there is a supervisor to that, so that he does not abuse and he's a God-fearing person and acts according to the written will of his father. Although if someone is not sure about that, it's always best to appoint someone who is not the beneficiary to the inheritance, so that there is no conflict of interest.
Ahsan, Jazakallah khair for that clarification. We've got a little bit of an interesting one over here. I think it's something that a lot of us think about during our lives or have set up during our lives, and that's regarding life insurance. Now, life insurance may not necessarily be coming directly to us. It may be going directly to a particular beneficiary. Are there any types of life insurance that we're not necessarily allowed to have, or are there any rules regarding life insurance that we need to be aware of to make sure that we are Sharia compliant?
Although it depends actually on, to give precise answer, it depends on your policy insurance or insurance policies, but in general, insurance and life insurance is an example of that, is in compliance and is acceptable, is a valid social contract, at least according to the Shia fiqh. Our fuqaha, and there's so much discussion behind these, our fuqaha accept that this is a social contract that like common people and intelligent people, they conclude between themselves, like between you and I, that I say that, look, if anything happens to your vehicle, for example, I will pay the compensation and whatever that any cost incurs on you, on the condition you pay me this monthly or annual payment. This is the kind of insurance. The same applies for life insurance. So in general, life insurance is valid Islamically according to our Sharia law. Although to be more precise, it depends on the policies. It might be an insurance policies that Islam does not endorse that. Like, for example, in certain cases, odd cases, that if the insurance companies takes the money and invest it on riba, because of the riba, it makes it problematic. Otherwise, if it's invested in any investment and they get benefit from it, that is again acceptable. As far as the will and the inheritance is concerned, because my understanding is that when I signed a contract of the life insurance with the company, I have to appoint a beneficiary to that. Naturally, the time that the money will be given, I'm no longer alive. This is the condition to life insurance. Because I'm not alive anymore, so it is not my estate. It will belong to the beneficiary or beneficiaries that I have introduced. Therefore, life insurance doesn't go under the law of inheritance. Therefore, life insurance in certain, unless if I write it, in fact, I cannot even write it as a will to say that mom, husband, wife, son, when I appointed you as a beneficiary, once you receive it, please give 1/3 of it to this cause. Sorry, with all respect, it's not yours to write a will about it. See, so life insurance doesn't go under the law of will nor under the law of inheritance. It purely belongs to the beneficiary or beneficiaries of that life insurance.
Ahsan, Jazakallah khair. I think that this clarification was very important because I've heard a lot of people say, oh, I'm paying for the life insurance. It's a policy for my death, and therefore I will control how it's used after I pass. So I think that's a very good clarification over there. We've got another question that's come in from one of our viewers. Can you agree on a distribution while you are alive, but have the actual distribution happen after death?
My mind was somewhere else, sorry, because I was thinking about that life insurance. I meant to say that that's the difference between life insurance and superannuation. Superannuation, because it's deducted from my wages and salary, so it was part of my property, my wealth that was saved for me. Therefore, I have a say on it. But for the life insurance, I didn't own anything to be saved for me. I paid for something for the future, and the contract from the beginning is that after I die, that money will be given. Therefore, because I'm not around to own it, I have no control over it. Sorry, Brother Mohammed, if you can repeat your question now. Okay?
No, look, that's perfectly fine, and I'm glad you mentioned the difference between superannuation and life insurance, because I think that that's something we want to get into in further detail in our next week's session, because I think our accountant and our lawyer may disagree with you on a few points that you've mentioned there, with all due respect, but we'll leave that for next week. Just getting back to that question, I know we're running out of time, so can you agree between your beneficiaries that this is how I want to distribute things while you're still alive, but then tell them you're not going to get it until I pass away?
It depends the way that we write it down. As I said, if it's only a recommendation that I tell you and I give a recommendation, and based on recommendation, ethically, the beneficiaries are recommended to follow the wish of the father or the mother or the deceased dear one. But jurisprudentially, there is no obligation. They have always the right to say that no, because there was no contract set at that time. It was only a recommendation. I pray for that. Inshallah, recite Surah Yasin for him and give some charity. But still, I believe that this is mine and it has to remain mine. But if I want to execute it properly, jurisprudentially, then they need to make a contract, and the parties to the contract, the beneficiaries, they need to sign it. Like what I say, make them co-owners. And then because they are the owners in this certain way and they have signed the contract, it is valid and it has to be executed accordingly.
Ahsant, Jazakallah khair. Haj Ali, was there anything you wanted to add to that?
I just wanted to tie up one loose end from a previous question about one's assets and liabilities. Sheikh, in the event that, let's say, if I pass away and my liabilities are greater than my assets, is there something that, is there a mechanism? What is the mechanism? And let's say it's to do with, like you mentioned, you'd made a distinction between my debts to God and my debts to people or companies or whatnot. How is that handled then?
In general, the liabilities of the deceased person for more than 1/3 has jurisprudentially has nothing to do with the beneficiary of the inheritance. So my children, in a simple term, if I die and I have my liabilities is more than 1/3 of my estate, is not their responsibility at all. But whose responsibility is that? Maybe the government decides, or however that it is. As a matter of fact, it is for this reason it's so recommended to write a will, and part of your will, if you have a liability that you know is more than your estate, your 1/3 of your estate, decide and settle it while you can. Because remember, while I'm alive, I have control over the whole estate. And or get someone to take the responsibility and the liability of your debts, and then you can die in peace, because at the end of the day I'll be liable in the hereafter. So this is does it answer your question? Was this the
Yes, Sheikh. Yep, that's fine. No problem. I think Brother Hasnain has one last question, and inshallah we'll close the session for tonight.
Sheikh, no, this is just going back to one of the previous questions that was asked, about if you have a house or if you have other investments and you may need to sell those investments to be able to distribute the shares as per the will and as per the inheritance. Is there a time limit on how long these processes can take as per the Sharia? That you have to do it within a month, 3 months, 6 months, 12 months, or is it open?
Yes, there is no time limit specified in the Sharia law to say that within a week, month, or year, similar to kafara, for example, or making up for fasting, that you have to do it within a year. For this one, we don't have any timeline, so to speak, specified, although the recommendation is that execute will as soon as possible. The sooner, the better it is. And also another recommendation, it reminds me to mention that when I die, once the community is educated about this, they need to understand that as soon as dad, mom, or somebody dies, before you start the funeral or anything, please check if they have left any will behind and execute it. Simply because maybe in my will I've written that I wish to be buried in certain place. I wish to be watched by certain person, for example, so that we have not acted ignorantly against my will. It's always based upon the death of the person, immediately get hold of the will and start acting upon it.
Ahsant.
Thank you, Sheikh. Sheikh, thank you very much for your advice and your guidance tonight. Inshallah, we'll wrap up this session with a few closing comments that include that we have a copy of an Islamic will that will be on our website tomorrow, inshallah, and we will also post the link to that on our Facebook page. Please keep in mind that any of the discussion and any of the advice has been general and not specific to your particular situation. The best thing that anyone can do is seek their own religious guidance in order to address their own specific needs and their own specific situation, as Sheikh Mansour also mentioned earlier on. Inshallah, next Friday night, we'll have a lawyer with us, as well as somebody who's more than an accountant, but just to put a name on it, an accountant. We'll have Michael Ayache to give us some legal advice, again, general in nature, and we'll have Hajdani Beydoun to give us some financial and accounting advice, again, general in nature, and we urge you to seek your own professional advice in any aspect that you might need. So once again, same time next week, inshallah, without the technical difficulties. The will be uploaded to our website tomorrow, and the link will be posted on Facebook as well. And of course, you're welcome to review this session on YouTube or Facebook so that your understanding of any of the issues that we've discussed is clear for you, for your benefit, inshallah. If you have any questions that you'd like to send across to us, you're welcome to do so either by DM on Facebook, on YouTube, or even directly by emailing us at info@ihic.org.au. And also you're welcome to send us a WhatsApp message as well. So we have, I think we have almost everything covered. And it's been a very technical discussion, but a very enlightening discussion as well. And Sheikh, if you'd like to close off the session with a short dua and any comments, that would be wonderful. Thank you.
Jazakallah khairan. Thank you very much, Hajj Ali. Thank you, Brother Mohammed, and thank you, Sister Rebecca, for the sign interpretation. God bless you all. Jazakumullah khaira. Yes, alhamdulillah, inshallah. It was an educational session and we continue it. Allow me, because it's Friday evening, to conclude with the al-faraj, inshallah. Allahumma salli ala Muhammad wa ala Muhammad. اللهم كل وليك الحجة بن الحسن صلواتك عليه وعلى آبائه في هذه الساعة وفي كل ساعة وليا وحافظا وقائدا وناصرا ودليلا وعينا حتى تسكنه أرضك طوعا وتمتعه فيها طويلا. صلوا على محمد وآل محمد.
Ahsan. Thank you, Sheikh. Inshallah, we'll see you all next week. Thank you very much, everybody, for joining us.